So,
we did it in.
Sorry. We never got your motion. Okay, other council business. We have some, one issue. Oh, I don't have the new agenda. So, Representative McGillvray, you have something on the agenda. We have it. Those of you who don't have, who have the green agenda, will see our next item, which was one that Representative McGillvray wanted to bring to our attention.
Thank you, Madam Chair. I think most of us have the decision in the Donaldson versus State that Judge Sherlock made, and I wanted to bring this issue to our attention with the goal of discussing a potential amicus brief on behalf of the legislature requested by Legislative Council. So just to explain my thinking here, it has to do with Article 3, Section 1 of the Montana Constitution, which Judge Sherlock cites in this case, which I will read. The power of the government of this state is divided into three distinct branches: legislative, executive, and judicial. No person or persons charged with the exercise of power properly belonging to one branch shall exercise any power properly belonging to either of the others. And in Donaldson versus State, plaintiffs brought suit with the complaint that they were unable to obtain benefits and family protections provided to heterosexual couples who marry. And just briefly, an example of that, same-sex couples may have the benefits of power of attorneys or joint tenancy, wills, custody and parenting plans, but they would not have benefits provided to heterosexual couples, such as marital deductions, intestate succession, homestead exemption, or divorce laws. So the plaintiff's request in this case was to seek a court order requiring the Montana legislature to enact domestic partnership or civil union statutes to enable these rights. They did not request a declarative judgment of the constitutionality on any specific set of statutes, if you read the decision. Judge Sherlock, in essence, denied their request and said the request for the court to require the legislature to enact a set of statutes would violate the separation of powers contained in Article 3, Section 1 of the Montana Constitution, which I just read. Judge Sherlock's decision has now been appealed to the Montana Supreme Court. So my point here is that without regard to the merits or lack thereof of the issues at hand in Donaldson, the point to me is that Judge Sherlock was supporting the autonomy and the independence of the legislative branch, and that the legislature should, in essence, petition the court to be able to file an amicus brief, and if that petition was granted, file an amicus brief on behalf of the legislature supporting Judge Sherlock's decision that indeed the legislative branch is equal, is separate, and as Judge Sherlock said, the court should not be requesting or requiring the legislature to enact a set of statutes in any area, whether that's tort reform, whether that's labor law, whether that's educational law, or whatever the issue, environmental law, you name it. The court should not be requesting the legislature to make law. So my proposed motion would be, as I mentioned earlier, to ask our legislative staff to petition the court to enable them to provide a legislative or an amicus brief to the court, and if the court grants permission, to prepare and file that brief.
Representative McGillvray, before we act on your motion, I wonder if we could have Todd, I know he did a little research